People think that the law means that if there's exculpatory information, if it's a juvenile, too bad, so sad for your client.
Multiple robbery-related charges, a co-defendant who was a juvenile, and a defense claiming duress. But a bigger issue is brewing: missing evidence and a potential violation of the right to a speedy trial.
All right, court is calling, and you've had a chance to review.
I have, Judge.
All right, court is calling 2024 CR 008124, 2024 CR 008173, and 2025 CR 007834, State versus Christian Alan Ruiz Garcia. Could I have parties announced for the record for the state?
Brandon Prada for the state.
Defense.
Raymond Martinez.
And are you Mr. Christian Alan Ruiz Garcia?
Yes, Your Honor.
All right, defense has filed a motion in each of these cause numbers to dismiss for lack of due diligence and violations of right to speedy trial. All right, defense, it's your motion.
And Judge, I would ask the court to allow me to basically make this argument in all these cases. They're all one series of events that all happen together, so.
Any
it
objection?
wouldn't be. any
None from the state.
All right, you may proceed, counsel.
But Judge, the court will recall, and I'll also bring up that one of the reasons for today's setting was to bring the defendant who was a juvenile, who's now in TDC, to court because we want him to testify in our case.
Mhm.
We can't even accomplish that because nobody has his birth date. I don't have access to his birth date.
Mhm.
State, and I'm assuming Norma was never able to
All right, and
obtain that information.
the court will note for the record that defense counsel did file applications for a bench warrant. All right, you may proceed.
And so, Judge, this case happened in June of 2024. Specifically, well, I thought I had the specific date, but I don't, but the court has it before it. It's in June of 2024, Judge. The defendant in this case has demanded his right to a speedy trial when we filed our notice of appearance back on June the 11th of 2024. The cases got indicted on August the 8th of 24. So he's been under indictment well over a year and a half. In terms of the harm issue, Judge, I'm just going to go through what I've recited in my motion. A critical witness, Joshua Garcia, who was a juvenile at the time, a co-defendant, I think everybody can agree that he's in essence a co-defendant, was charged in juvenile court.
And just one moment, state, do you agree that's co-defendant?
It is, Judge.
All right, you may proceed.
And that his cases were adjudicated in the juvenile court. And then so much time has passed, Judge, he actually has been released from juvenile and since it was a certification, he was then sent to TDC, which we believe he's there. We haven't actually found him. And today we were set for purposes of seeing whether or not he responded or that he was presented to the court pursuant to our bench warrant. In this case, Judge, if you recall, the defense has been asking from the very beginning, because he's a co-defendant and because he has his own set of discovery, and more importantly, in this case, he had other aggravated robberies in addition to the ones that were with my client. So our theory was, well, it wasn't our theory, our defense is that my client was participating in the particular case he was involved in under duress. And we wanted to be able to demonstrate in the trial of this case, the character and the nature of this co-defendant, what he had done in the past, his use of weapons, his MO, if you will, to show that because my client was only involved in this particular date and he wasn't involved in the others, to help support our suggestion that he was operating under under duress. But we can't get any of that evidence. If the court will recall, more than a year ago, this court had a hearing where the court asked the juvenile prosecutors to appear and to answer to why they wouldn't give us this evidence. And they in fact appeared on Zoom. And this court had the opportunity to question them and find out.
And they said they would not be giving the evidence.
They refused.
Yes.
One of the few times I've seen a lawyer in this court actually tell the judge, no, Judge, we refuse to do what you're telling us to do. Okay, so we stepped back from that and we regrouped. We found a provision in the code that says that we can petition the juvenile judge to have a hearing and to determine whether or not circumstances exist where he would order the disclosure of the records. So we did that. He denied it. They argued against it. And he denied it, except to the extent that he said we could review the file that pertained to our case. Well, that was kind of pointless. We already have the file that pertains to our case because we have discovery from my client. But we'll give it a go. Never got them. We provided case numbers to the state. The state said we don't have those files. And to further clarify the record, the juvenile prosecutors told us that they, in essence, took into consideration the cases that my client is charged with and never really pursued them because he had so many others that he got prosecuted on. So they weren't even sure where those cases were in the system. Not sure they even got filed on.
And when you say other cases, you're speaking about your client's co-defendant.
Correct.
All right.
The co-defendant had double-digit number of aggravated robberies. And so the ones they chose to prosecute didn't coincide with my client's case, unfortunately. So that was another area in which we were not able to get the records. So we said, well, let's get the defendant here. Let's get the co-defendant here. Maybe we can get through him what we need. But we can't get him here. And I will tell you, Judge, that Abe Garza, and I think we've talked about this before, and I think he's been here before, is the juvenile's attorney. And he has suggested to me, and as an officer of court, I will tell you that his advice to this client is going to be not to say anything, which is understandable because those cases weren't prosecuted. They still could be, theoretically. And he could expose himself to all kinds of problems, not only with those cases, but with perjury and everything else. So even if we were able to get him here, I don't believe we would have been very fruitful.
All right.
But
And the court will note for the record that in regards to discovery, the request by the defense for discovery has been well over a year. The juvenile prosecutors did zoom in and no one had any objections to the prosecutors zooming in. And they informed the court that they would not comply with discovery. And so state, here's my question. With regards to juvenile, if it is information that is exculpatory, basically what I'm being told is you don't get it because it's a juvenile. They won't even give him the date of birth of the witness in order to have the witnesses appear by bench warrant. So, and that ship has sailed with regards to bench warranting him here because this has been over a year. So that's what my understanding is from juvenile prosecutors, and their understanding of the law is that even if it is exculpatory, his client is not entitled to it because the other person is a juvenile.
And Judge, that's as confusing to me as it is to everyone else here. Under 3914, if it's relevant, then it is to be given to the defense. I don't know. My knowledge of juvenile law is rudimentary at best. My argument would be that any discovery that would come from the co-defendant would also be, all this stems from the same incident. So all of the discovery, be it for the co-defendant or for the defendant standing here, would be exactly the same because it all stems from the same incident.
But I mean, do we really know that? Because he hasn't been given access to it, and defense is entitled to exculpatory evidence. And I will say that the prosecutors in this court, you all are not the prosecutors who denied this defense the discovery that they needed. However, you all are all working for the district attorney's office. So everybody's responsible for discovery.
Judge, sorry if I could just
Yes.
chime in here, but I think like the
And
distinction.
if you could announce.
Yes, it's Megan Galloway for the record. The distinction in this case is that there's a legal reason why it's not being provided.
Mhm.
I believe under the family code, it's protected because the co-defendant was a juvenile at the time. And so we've certainly exhausted our resources. I understand that the state is a state and we are working together. However, the divisions are walled off from each other. So we don't have access to that information. So I want the record to be clear about that. I am not in possession of those materials. And then albeit whatever the juvenile prosecutor did come in here and say, the petition to the juvenile court was still made. And that court determined that it should not be turned over. And so at this point.
And I know that the prosecutors in this court did all they could to get the information to defense. Is that correct? The attorneys in this.
in this court, of course, Judge,
Yes.
and I don't dispute anything that counsel just suggested to the court, but that could have been avoided.
Mhm.
When they went to prosecute that juvenile, all they had to do was call the prosecutor in the 187, say, hey, we're getting ready to go forward on this guy. This is our deal we're going to work out. Let's discuss what you're doing with your case. Maybe they would have made mine go forward first. I mean, there's so many ways it could have been avoided.
Well, I know there are different ways it could have been avoided, but I'm just going to deal with the facts that's
Yes.
being presented before me. And I want the record to be clear that the prosecutors in this courtroom did all they could to obtain the information that you were requesting.
I'm not disputing that, Judge.
And what I will say again, it appears that prosecutors in other courts, whether it's juvenile or not, people think that the law means that if there's exculpatory information, if it's a juvenile, too bad, so sad for your client. And the defense can't even get to the point of his defense of perhaps duress because he's not being given access to the information. And this has been going on for over a year. But I just want the record to be clear that the prosecutors in this court, I don't think, I know that you all did all you could to obtain the information.
Then Judge, just to address one thing, the date of birth of the co-defendant was provided in the discovery that we received, so.
Okay. He should have that.
has
Okay.
that.
All right.
Um,
And I understand what you all are saying about the bench warrant with that. But we're still at a point where this court thinks under the law, the defense is entitled to exculpatory information, whether the person is a juvenile or in the juvenile system or not, because then what are we, what are we really doing? He can't present his defense, and nobody knows, for the record, nobody knows if it's exculpatory or inculpatory because he's not being given it. And obviously based upon what the defense is presenting to the court, that their defense is or will be, he's saying as an officer of the court that he believes the documentation would show that potentially.
It would help us to prove that point, we think, Judge.
So is there anything else from either side?
Judge, I just understand that. I understand what the court has explained. I just don't believe that dismissal is a proper remedy in this case. And so I don't know if the court would be able to reach out to Judge Shaw, because I mean, that was his ruling. So at this point, my hands are tied because that was his ruling under the family code.
Mhm.
And I would agree that neither party knows what is in those records that are over there. However, if we're getting to the point of, or their argument of duress, there are pieces of evidence where, in this case, that were turned over, like statements from the defendant that do address that if they would like to put it forward.
All righty. Is there anything else from either side?
I think our position is pretty clear, Judge.
All right, just give me 5 minutes and I'll give you my ruling. Thank you.
Your Honor.
All right, who's the prosecutor on this? All right, so what is happening with this case?
Your Honor,
Motion to withdraw will be submitted to the court, and the state is asking to alter them in conditions for no weapons and to ensure he pays at least $50 a month towards his restitution.
All right, so how much, so the restitution is $608.82. You've been on probation since April 2024. Why, have you paid anything towards restitution? Why not?
I don't have an excuse. I just, tender by showing defense something that really.
Are you employed?
No, not right now.
When's the last time you had employment?
November.
How much are you going to be able to pay a month towards restitution?
Do like 100.
All right.
Additionally, Judge, the state proposes that, and this is from an email from between 88 Jones and I and Mr. Simmons. The state is also requesting that the defendant provide proof of employment within 30 days.
Your Honor, in talking to my client right now, I don't know that there would be an issue if the court would be willing to, he's expressed a commitment to me to have this paid within 30 days. The $600, $608. Is that correct? Yes.
Well, I'm gonna have him pay $100 per month, and if he can pay the $600 in that time frame, then he can pay it in that time frame. If you give that to probation. So I withdraw the motion. I'm gonna alter and amend your conditions. For you to pay at least $100 per month towards restitution. There's to be no possession of firearms, and you're to provide proof of employment within 30 days of release. And there's to be no employment as a home health care provider with minors. Do you understand?
Yes, ma'am.
Is there anything else you need from the court to be successful? All right, the range of punishment for this offense is anywhere from 2 to 20 years. You understand?
Yes, ma'am.
So you better start doing things differently, okay?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome. All right, is there any other evidence that either party wishes to present to the court?
Not at this time, Your Honor.
Judge, Mr. Alvarado would like to make a statement if you care to swear him in.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Francisco Alvarado.
All right, defense, you may proceed.
Okay, you wanted to make a statement to the judge?
Okay, everyone, please whisper.
I'll speak loud enough so this way you can hear everything you say, okay? All right, go ahead.
I just wanted to say that this was a terrible mistake and something that I will never come back to. And I just hope after this I can get my life back on track and continue on what I was doing. Is I live and learn, and I will not go back to anything I did.
Any questions?
No, Judge.
All right, I have a question if there's no objection.
Sure, Judge, go ahead.
All right, from State's Exhibit number 1. It appears, oh, this is.
That's the right one?
No, this has Courtney Price on it.
Oh, that's the other
I don't
girl over
believe
there.
we tendered any exhibits.
Oh, I saw
No.
that. Yes, I was,
Oh, yeah.
Only
Oh, that's
like our
right. It
stipulation,
wasn't the
but
plea, that's right.
okay, I'm sorry. It's okay, I was like, I thought my steel trap was failing me because I was like, I can't remember, maybe I'm wrong.
And Judge, just, Mr. Alvarado's parents are here in the courtroom and in support of him. I've spoken with them as well. They've said they've never had a bit of trouble from Francisco before this. And
Mhm.
it's very out of character for him, and he's told me the same thing. And as I told you the other day, he's been nothing but respectful. And other than showing up at 11 the other day because he got multiple messages from his sponsorman telling him so, he's been here at 9 o'clock every other time. And we really asked the court to grant his application for deferred.
All right, I do have some questions. Where are the items that were in the vehicle?
Where are the items?
Mhm.
Of what items?
The person's grandfather's ashes?
I didn't touch any of that. Everything that was in the car was left in the car.
So who took items from the vehicle?
I didn't, Your Honor. I didn't touch anything. Everything that was in the car was left in the car, so.
All right, how did you obtain this vehicle?
Um, we had got it, one of my buddies did, and I ended up with the keys and just ended up joyriding it.
No. I mean, you're skipping over some things. Counsel, do you want to ask some questions about that? Like how he ended up with this vehicle? Because with regards to the PSI, they're saying some sentimental things are missing. And I'm trying to figure out where these items that were in the vehicle.
When this, I mean, where did this happen? Where did you see the vehicle first?
I seen it here in San Antonio.
Well, I don't mean that. I'm gonna be more specific. Where?
One of my friends had it.
Okay. You brought it to your house? You went to his house? What?
Yeah, he brought it to my house.
Okay. And then you ended up driving from there? Or
Yeah, he ended up giving me the keys and I ended up driving it after that.
did you inspect the contents of the car at that time?
I did not.
Okay, so before your friend brought it over there, who is this friend? What's his name?
Jaden,
Okay. Or Jaden brought it over there. Possible that some things in the car may have been taken by him?
as far as like ashes and all that, I don't think he would touch any of that, but I know I didn't grab any of that.
Well, I mean, when you got the car, did you immediately get in and start driving?
I did.
Okay, and how long was it after that that the police tried to pull you over?
Like 30 minutes.
Okay, but you'd been driving the entire time?
Yeah.
You didn't stop anywhere?
No.
You didn't stop to open doors or look in the trunk or anything like that? So you're just driving around and around? Okay. And once you were pulled over, you no longer had anything to do with the vehicle at that point, is that right? When you were being pulled over, do you know if you or your friend Jaden or anybody else that may have been in the car was throwing things out the window or? And I don't think there's any evidence of that, Judge, either, but just thought I'd ask.
Any questions? All right, so let me just tell you, you said that these are, you know, you made a mistake. No, these are choices. You understand? These are not mistakes. These are choices you made, and that's why you are here. How old are you?
23.
So this person says that the total amount that they're able to account for is $5,000.
For, I haven't seen anything about restitution, Judge, but I'm glad to have a hearing or inspect the,
I mean, they're
Okay.
asking for $5,000 restitution. So is there going to be any objection to that $5,000 restitution?
no, Judge.
All right. State, unless there's anything else, you may be excused.
Thank you, Judge.
Thank you. And cause number 2025 CR 012-615. The court is going to find you guilty. The court is going to sentence you to 2 years in the state jail facility, suspended and probated for 5 years. There's to be proof of employment within 45 days of release. No employment as a home healthcare provider or with minors. Regular reporting by Zoom or in person. Regular random UAs. Field visits 1 time per month for 6 months. There's to be restitution of $5,000 to Demarion Jasmine. There's going to be 200 hours of community service restitution. Do you have any children? All right. The court is going to order the felony theft course. Once that's completed, the community service hours will be deemed satisfied. And this is the run concurrent with 2025 CR 012621. Probation, is there anything else with regards to that cause number?
No, Judge.
And that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because that's a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? And cause number 2025 CR 012621. Court will find you guilty. Court will sentence you to 6 years in the prison, suspended and probated for 5 years. There's a $1,500 fine that will be probated. This will run concurrent with 2025 CR 012615. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors, no unsupervised contact with minors, 200 hours of community service restitution. The court is going to order the defensive driving course. Once that's completed, the community service hours will be deemed satisfied. There's to be no driving without presenting to probation proof of a valid license and insurance. There's to be field visits 1 time per month for 8 months. And there is to be supportive outpatient treatment with probation. And probation, if you'll test for levels.
Yes, sir.
Probation, is there anything else?
Okay.
Is there anything else you need from the court? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Thank you.
Francisco Alvarado is back before the judge for sentencing in 2 felony cases. He's asking for mercy and deferred treatment, but the court is about to dig into missing property, restitution, and accountability.
Court is calling 2020 CR 9867 State versus Gloria Jean Hernandez. Can I have parties announced?
Albert Chidas for Ms. Hernandez.
And are you Ms. Hernandez?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Gloria Jean Hernandez who's placed on community supervision on January 12, 2021 for a term of 5 years for the offense of unauthorized use of a vehicle? Is that you?
Yes, ma'am.
All right, state.
In violation of condition number 5 in Dare County, Texas, the defendant Gloria Jean Hernandez did then and there fail to report to the supervision officer as directed for the months of February and March 2021 in violation of condition.
How do you plead to that? True or not true? State. Any objections?
No objection,
Did
Judge.
you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, sentence you up to 2 years in the state jail facility?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 5? Court will find violation of condition number 5 true. Is there a proposed agreement?
There is no. State is asking that you grant the state's motion for both the defendant's community supervision and sentence her for the 2 years in the state jail facility based on the plea of true. The defendant was placed on probation in January 2021 and failed to report thereon.
All right, defense.
Judge, I'd like to call my client as a witness.
All right, can you raise your right hand? Do you solemnly swear or affirm that that the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Hernandez.
All right, you may proceed.
Thank you, Judge. Ms. Hernandez, you recall being placed on probation on January 2021?
Yes,
Were you living in San Antonio at the time?
I will.
Okay. And did you report to probation?
When I first got out, first month,
Okay. And when you reported, what were you instructed to do?
I was supposed to give a drug test and, laws come out dirty, they were supposed to report me back to the judge and give a drug test, I believe. And when my probation officer asked me if I was dirty, I told her I would probably still be dirty because I was in here for maybe like 3 weeks when I got out. So after that, she said that she was gonna have to report me to the judge. So I just didn't report no more after that, and I didn't get in trouble.
Okay. And how is it that you got arrested and brought to this court?
This time,
Yes.
oh, I was working at a job site in Ohio. I live at now, and they served a felony warrant and they ran my name.
Was the felony warrant for you or
No,
someone
no,
else?
no, the owner of the house.
Okay. And so when the police went out, they ran your information and they found out warrant out of Texas?
Yes,
Okay. This whole time, have you been living in Ohio or in San Antonio, or where have you been living?
I've been living in Ohio. I moved to Ohio back in February of 2021.
Okay, so the very next month you moved to
Yes.
Ohio? Okay, in Ohio, have you been arrested for any offenses? Okay, are you asking the court to keep you on probation?
Yes,
Are you willing to do everything that you're supposed to have done on probation?
yes.
No further questions, Judge.
All right, state.
Okay, Ms. Hernandez, so you're saying that you've been living in Ohio since you were granted probation in
After.
20. Okay, and I couldn't quite hear you, but are you saying your probation officer told you that you still have to report?
No, 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 no.
Okay, sorry, can you repeat what you
No,
said?
she said that, when I got out, when I reported, she said that she asked me if I was dirty.
Okay,
And I told her that I probably was still victim. I wasn't, after not even a month. And she said she would have to report me to my judge. So then I didn't report after that.
oh, okay.
Yes.
All right, okay, so then the address that you provided to probation back then, do you recall that being 3550 South Henderson
Yes.
Street? How do you look at that location?
I was there for a while before, I got arrested.
Okay, and so is that where you're saying you were there before you got arrested for the unauthorized?
Yes.
Okay, and then so when you were placed on probation, did you go back and live there for a period?
No, I moved, I was only there for about a week and then I moved to Ohio back in February. Cause I'm from Ohio, but I was here.
And so when you moved to Ohio, did you notify your probation officer that you were gonna be moving or having a change of address?
No,
Okay, and then were you aware that your probation officer had made multiple phone attempts to reach you and also visited that location, South Duress, to find you and could not?
no,
Okay.
I didn't know I was supposed to wear it.
And so I guess your attorney said that you're asking this court to be still on probation, is that correct? And so my question to you is, why do you want to be on probation?
Because ever since, I left here, I haven't been in no trouble. I've been doing good. I have a job over there. I have my house. And
It has been going on 5 years now, I think. And I haven't got admitted in trouble. When I was here, I could get in trouble like back to back, like.
And I hear what you're saying, right? But you would agree with me that the point of probation is to get people help so that they can be rehabilitated, right? And so at the time, right, when you were still using drugs, the correct choice at that time would have been to be forthcoming with your judge so that you could get treatment for that, right?
But I haven't been on drugs since, so.
Okay, but have you provided any drug tests to the probation department? So we're just gonna have to take your word for that, right? There's no evidence of that, right?
Yes, ma'am.
Okay. We pass the witness.
Any further questions?
No further questions, Judge.
All right, it states that as a part of a plea bargain agreement, that money was to be paid to SAPD for the drug testing. Has that been paid?
I don't think in,
And no, I was aware of that.
Okay.
Judge, no payments have been made.
All right. Counsel, she didn't sign the, form. All right, part of the number one thing you have to do when you're on probation is report. Okay?
Yeah.
Mhm. All right, so this is what the court is going to do. The court is finding violation of condition number 5 true. The court is going to grant the motion, revoke. The court will sentence you to 18 months in the state jail facility, give you credit for any time served. The court is going to request the therapeutic community, and there's to be $57 restitution to SAPD for drug testing. There's to be no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you, okay? You're welcome. Thank you. All right, is state, do they have any objections?
They do.
Okay,
And I talked to probation and probation also has an objection.
all right. All right, the court is calling 2025 CR 006933 State versus Valerie Marino. Could I have parties announced for the record?
Gallery for the state.
Travis Kettner, Your Honor, for Valley Moreno, we're ready.
And are you Miss Marino? All right, it's my understanding that defense, you're asking for early termination?
Yes.
Yeah, yes,
Oh,
Your Honor, that's okay. Judge, my client has paid all the restitution. She has also paid the court costs. She is current on her fees. Her last drug test was clean. Her first one or two were dirty, but her last one was clean. Your Honor, my client just got out of the women's shelter within about the last week or so.
Mhm.
And she was a victim of a sexual assault. She was also the victim of a currently pending felony domestic violence case here in San Antonio.
Mhm.
The reason we're asking for her to get off of probation is the women's shelter is trying to help her get housing, and the felony probation has slowed it down, to say the least. And so she has no priors. Obviously, she's done what's been asked of her, and I know it is early, but it would certainly help her life quite a bit if she could move on.
All right, state.
But we're not in agreement at this time. The defendant was placed on deferred adjudication on October 27th of 2025. So I don't think that the statutory requirements has been met as to that. But further, because there is a victim that was involved in this case, we would request further supervision to keep the no contact order.
All right, so here's the issue. Like, I'm always gonna follow the law. And it's true, you haven't met the statutory requirements for me to even consider early termination. But once you do that, I won't be here to address that issue, but you'll need to address it with the next person who's here. But if I were here and you were doing well, I would grant the early termination. So the record will show that I would grant the early termination and hope the person who comes here next will grant your early termination if there are no issues. Probation, do you think she would be appropriate for reporting by mail or either maybe reporting once every 2 months to have? All right. All right, so you just have to continue abiding by your conditions, okay?
Is it possible to reduce her fees, Judge? I think she's paying the full 60 right now. How much you pay for fees?
I don't know, I just give hundreds of dollars.
Well, this is, well, I will tell you what, with regards to fees, there's a law with regards to that too. They have a data sheet you can fill out, and that data sheet, that will be based upon, once you completed it, I'll be able to view it and they'll let me know whether or not you should be paying minimum amount or if you should be paying nothing at all. And they'll base it upon your ability to pay. All right, so probation, just ask probation to make sure that
Okay.
that's done. All right,
Thank
thank
you,
you.
Judge.
All right, we're back on the record in 2024 CR 008124 and 2004 CR 008173 and 2025 CR 007834 State versus Christian Alan Ruiz Garcia. Just for the record, the court will note that discovery issues have been ongoing in this case since, at least according to the court's docket, since October 31st, 2024. And with regard to the defense's motion to dismiss, and each of the cause numbers, the court will grant the defense's motion to dismiss for want of speedy trial. It will be based upon the defense's inability to proceed with trial due to the lack of discovery. Is there anything else?
There you are.
All right. Thank you.
Thank you, Judge.
Thank you,
Excused.
Hello.
Morning, Judge.
Good morning. Let me see. Odyssey is moving slow. All right, so where are we on to the discovery with phone records, restitution amount and all of that?
We have received a majority of the items that were missing last time, Judge, but outstanding. Defense would like me to determine the time order at which 911 calls came in. There is potentially a missing statement of a witness and then some text messages that may or may not be missing that I'm gonna send an email right now and determine.
All right, how long do you need?
At least 2 weeks, Judge.
All right, Ms. Ferguson, I need a recall for discovery for 3 weeks.
Yeah.
And this will be final discovery. And State, at that time, you need to be prepared to tender an offer.
Yes, Judge.
All right, thanks, State.
Thank you.
All right, Miss.
That way I can look into that issue.
All right, Ms. Ferguson, can we recall this for next week, Thursday?
Yes, yes, Judge, but in the meantime, my client has a request. He's still in federal custody, Judge. He hasn't, his sentence is set to expire this year, matter of fact, in a few months.
Mhm.
He's asked me to ask the court if he could appear by Zoom for that next setting. Because if the case is going to continue to go forward, he'd like to be able to post bond on this case and defend it the way we normally would. He's got literally the last few months of his sentence. in
Yeah.
federal.
No. All right, Thursday, Ms. Ferguson?
Yes, ma'am.
Is everyone okay with Thursday?
I'll be here, Judge.
Thursday will work.
All right, we'll have you all back on Thursday.
And right.
Okay.
That's the 19th.
Okay.
Sounds great.
Thank you, Your
All right, you're welcome. On this case, what is happening?
Judge, he has two charges. One is a possession charge that came out right at 1 gram.
Mhm.
He has a family violence case. The problem is the state cannot give me an offer on the family violence because the victim, I guess, has a charge against her and she has a lawyer. And they need to, if I'm not mistaken, they need a permission from that lawyer to speak to the victim.
That's correct. The victim has her own criminal charges pending.
And who's the attorney?
Eric DeWalt.
Oh.
He hasn't responded back to me yet to grant me permission to talk to him. So until I can talk to the victim is when I can give an.
All right, Norman, can you call Eric DeWalt?
Yes, ma'am.
All right, so she's gonna call Eric DeWalt before you all leave here and see if she'll allow you all to talk to the client.
There you
Then
go.
we're gonna recall this.
That'd be great, but
All right, so were you able to find the discovery with the surveillance?
No, Judge, it's my belief that it does not exist. I've emailed SAPD, assigned detective, but also the regional Home Depot people, and they have not provided me any and not indicated of its existence.
All right, and then the other thing, has an offer been tendered?
Yes, Judge, it was tendered via email on February 13th.
All right, sir, how old are you?
54.
All right, Ms. Ferguson, set this in 2 weeks for a plea deadline date, please. All right. For a plea deadline date?
We can do March 23rd.
All right, we'll come back on March 23rd.
Honor.
At that time, you need to let the court know whether or not you've reached agreement. If you have not, it's going to be a quick turnaround for a jury trial. All right, thank you.
Thank you, Your Honor.
Counsel. Good
Thank
luck
you.
on your trial.
Just have a seat, sir.
Court is calling 2025 CR 012615, 2025 CR 012621, State versus Francisco Alvarado. Can I have parties announced?
Lauren Espinoza for the state.
Robert Barons for Mr. Alvarado.
And are you Mr. Alvarado? You entered a plea in each of these cases. Is there a PSI and TAP evaluation?
Oh, the PSI, I'm not sure about a tap, Judge. We were here last week and you
Yes,
were gonna bring him back Friday and then brought him back today.
yes.
I don't think there's a tap.
I have the exhibit, Judge.
I'm sorry?
I have. the
Yes, there is a
exhibit.
tap.
All right. Just one moment, let me put this into the system. All right, where are we on discovery?
Your Honor, I represent Mr. Givens on 2 indicted cases, and there are 2 unindicted cases that are coming. The state didn't have a file today. This is our first setting. I'm reaching out to Mr. Givens, drug court supervisor, and we are downloading discovery, but there's a few different angles that we're drawing everything together. The state is knowing that I'm asking for a reset to gather all 4 cases together.
All right, Ms. Ferguson, I need a 45-day reset for discovery.
Is that all you'll be needing, Your Honor, or after the date? Thank you so very much.
That'd be April 20th. 1 second.
No, April 20th is not the right day.
To April 27th.
All right, we'll have you all brought back on April 27th. That'll be for discovery. Do you have any questions? All right, thank you.
Thank you, Your Honor.
You're welcome. And I see there's another case that's awaiting indictment.
Yeah, so I talked with Family Violence and they made an offer to TIC that case in exchange for a plea on the other charge.
Mhm.
I talked to Brandon, he's gonna contact the complainant. I just want to see if we can get a plea bargain deadline.
How much time are you asking for?
Brandon, what do you think? Couple weeks,
Yeah, a couple weeks, 3 weeks.
3 weeks?
All right, Ms. Ferguson, I need a 3-week reset for a plea deadline date.
I can do March 26th.
All right, we'll bring you back on March 26th.
All right, thank you, Judge.
All right, thank you. All right, and what's the status?
Judge, just a quick update. I spoke with felony drug court. There had seemed to be some type of clerical error in the system to where it was showing that a motion to revoke was filed on Mr. Hurd.
Mhm.
That was not the case. He's never had a motion to revoke or anything like that. Felony drug court initially denied him because of the error that was in the system. We've got that cleared up. They are willing to accept his case and he is supposed to be accepted tomorrow.
Okay,
That is our understanding, Judge. We did find a clerical error, brought it to the court's attention. That was rectified. And it's our understanding as per probation that he does meet criteria for that. I also did check and he does not have any parole holds or any holds that would limit him being into the program. And we're very appreciative of this court saying that referral for him to get into felony drug court. And I spoke with him about the program and how we're looking forward to seeing him graduate and walk across the stage one day, having changed his life around the help of this court. So we're very appreciative of that, and he's looking forward to this opportunity to change his life.
all right, good luck to you. I will, even though I'm not gonna be here, I'll still show up to your graduation. All right, congratulations. You're welcome. Have you conferred with the state?
I have. I've conferred. The state's just asking for revocation, probation is asking for GDRF. But they evaluated him, did the first phase, I guess, of the mental health evaluation,
Mhm.
and he's scheduled for the Tacoma or whatever, June the 9th. And so I understand from probation that because of that, he wouldn't even be eligible to go to GDRF until after that's completed.
All right, so I'll hear the motion to revoke unless it's gonna be contested,
Well,
because I'm not waiting till June 6th for some.
okay. Right, I think we're prepared to. The problem is we don't have an agreement on all of it then, if that's what the court wants to. Let me talk to the state again,
Okay, sure.
but it will be probably.
Okay. All right, who's next?
Yep. Antonio Corrales, page 2, 5 down.
Judge, Mr. Garza, state is tendered a dismissal on.
Oh, thank you.
Case.
All right, Antonio Carrizales.
Corrales here?
Corrales. All right, thank you.
Morning, Judge.
Good morning. So how is Mayor? I know she's doing great though.
She's taking it in stride, Judge.
Yeah.
I, on the other hand, have like a strange one-sided sunburn from being out there helping her out because my left side was facing the sun most of the day.
So on this case, you have all discovery?
I think we do, Judge. There's a lot of it still coming through it all, but I think we were set today for the state to make an offer, which they had made one.
Okay.
I need some time to discuss it with my client and the pros and cons of doing it.
How old are you? 27. 27?
He also suffers from some mental health issues, so we want to coordinate with his care team on that as well.
All right, Ms. Ferguson, I need a plea deadline date in 45 days.
Perfect, Judge. Thank you.
April 27th.
All right, we'll see you back on April 27th. Once you sign the reset form, you're excused.
Thank you, Your Honor.
You're welcome. All right, Frank Garza.
Yes, Judge.
Court is calling 2025 CR 005952, State versus Frank Garza. Can I have parties announced for the record?
Donald Wilson for Mr. Garza.
And are you Mr. Garza? All right, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it? Are you the same Frank Garza who was placed on community supervision in 2025 CR 005952 for the offense of unlawful carrying of a weapon with a felony conviction on August 26, 2025 for a term of 2 years? Is that you? All right, state.
I apologize. I believe I need a motion. When I was looking at the court file, I believe that the judgment was for a reduction attempted possession.
Yes.
Or unlawful possession, the
Mhm.
third degree on.
That's
So
correct.
so at this time, I'm gonna ask to amend the motion to revoke for it to read offense of attempted unlawful carried weapon.
Any objection?
No objection, Your Honor.
All right, are you the same Frank Garza who was placed on community supervision for the offense of attempted unlawful carrying of a weapon with a felony conviction on August 26, 2025 for a term of 2 years? Is that you? And did you review the motion to revoke community supervision and the first amended motion to revoke community supervision with your attorney and understand it? All right, state.
Violation of condition number 4 in Fair County Tax Superintendent Frank Garza did then and there fail to report to the supervision officer as directed for the months of November and December 2025 in violation of petition number 4.
To that, how do you plead, true or not true?
And we'll wait for that.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court would find it true, grant the motion and sentence you up to 2 years in the prison?
Speak up.
All right, you have to
Yes,
speak up.
ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. Is there an agreement?
There is not. State is asking that you grant the state's motion, revoke the defendant's community supervision, and sentence him to the underlying sentence of 2 years in prison.
All right, defense, what are you requesting?
Judge, since he's been locked up, the probation has completed a TAP evaluation and started a mental health evaluation. And they feel that he's in need of some mental health assistance, and I believe they're recommending DDRF. I believe that's a good program for Mr. Garza. I don't know if you remember this case a few months back when you placed him on probation. This is one where he's homeless and he found the gun and was trying to turn it in. And so it was a technical violation of the law. And that's why we ended up with a plea of attempted possession of the gun. He's still homeless, still struggling with those types of issues, still struggling with his mental health issues. And we believe that getting him some help while the court has jurisdiction, as opposed to just placing him in an incarcerated situation, would be a benefit to him and to society. So we would ask the court to amend for DDRF and get him
I
some
mean,
help.
I understand his issues, but why isn't he reporting? You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
No.
All right, you can lower your hand, state your name for the record.
My name is Frank Dodson.
All right, why are you not reporting?
The time frame of the housing where I was staying at, where my probation officer actually requested address, I couldn't use the Haven for Hope address because they're over capacity. So unless I'm staying there, I can't use it. So
No, that has nothing to do with reporting. I'm like, why didn't you?
I reported it just it was like a 2-month period of separation. I think I kind of missed the date on my reporting. So I do admit, but the situation trying to have somewhere to stay, you have to constantly be moving around, waiting for housing downtown. So I have to wait downtown. So finding a location to be at, very difficult with the law enforcement officers constantly asking us to move.
All right, but it's saying that you didn't report for November and December, which means nobody has seen you since October.
Well, I stay right here downtown, like right next.
Yeah, I mean, I know you're saying you stay right downtown, but probation doesn't know that because you're not reporting to them.
Well, I let the probation know. I literally stay like right where the buildings are. That's where we're at. We just have to be moving around the location because we can't stay. We can only stay like 72 hours.
No. I understand what you're saying. That has to do with you not having a residence, but it doesn't have anything to do with you not reporting to probation. So I'm trying to figure out, why didn't you report to probation? You say you're moving around, which means you can get from one location to the next. All you had to do was report to probation once a month. So I'm trying to figure out why you're not reporting to them.
I mean, I could tell you, but I mean, it's going to be considered like as I don't want to consider it as an excuse, but.
No, just tell me, because I'm
My
trying to
daughter
figure
was-
out where you're coming from.
Well, my oldest daughter was beaten, so I was handling that. So helping her, I even getting her in there, that's what she went. Her boyfriend's actually locked up right now. He beat her with a gun, so that was one of those situations.
Okay, I understand that. And I'm internalizing everything you're saying, but unless your daughter was somewhere where you need to be with her for 2 months, which normally in a calendar, is 60 days.
She stayed with me 30 days on the street until she actually got accepted in, because that's the requirement.
Okay, but still, that doesn't explain why you didn't report at least once out of the month for November and December. That's what I'm trying to figure out why. All right, any questions?
No, Judge.
All right. Here's the thing. I mean, the number one thing you have to do is report.
I needed like 7 more classes for pragmatism.
Okay,
I mean, I was on the top.
I need signatures.
This is mostly one of the guys. What did she say? What do I say?
All right, the court is finding violation of condition number 4 true. The court will grant the motion, revoke, sentence you to 2 years in the prison, give you credit for any time served, and the court will recommend the therapeutic community. You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. All right, good luck to you.
Final outcome. The judge revokes Garza's probation and imposes the original 2-year prison sentence, with credit for time served and a recommendation for therapeutic treatment. Missing those probation check-ins ultimately cost him his freedom. Like, share, comment, subscribe.